driving economies forward and transforming societies. However, to nurture and protect these innovative ideas, a robust understanding of intellectual property rights is essential. Intellectual property rights or IPR encompass a range of legal protections granted to creators and inventors to safeguard their works, inventions, designs, and brands. These rights not only ensure that innovators can reap the benefits of their creativity, but also foster an environment that encourages continuous innovation and investment in new ideas. We are honored to have Mr. Sanjeev Kumar Jain, an advocate with an LLB and LLM in cyber and intellectual property rights, as our esteemed speaker today. Mr. Jain's vast expertise and experience in the field of IPR will provide invaluable insights and guidance, making this session an enriching experience for all of us. By the end of this session, I hope you will have a clear understanding of the foundational concepts of IPR and be inspired to harness the power of intellectual property to protect and propel your innovative ventures. Let's embark on this journey together and unlock the potential of your creative endeavors. Now, it is my great pleasure to introduce our distinguished speaker, Mr. Sanjeev Kumar Jain. Born in 1967, Mr. Jain has carved an impressive career as an advocate, and his expertise in cyber and intellectual property rights makes him an invaluable asset to today's session. Mr. Jain holds a BSc in Computer Science and a PG Diploma in Tourism from the University of Delhi. He further pursued his legal education, earning an LLB and an LLM in cyber and intellectual property rights from Mewar University, Rajasthan. He has been practicing advocacy in various courts across India, bringing a wealth of knowledge and experience to the legal community. Before transitioning to law, Mr. Jain spent over 2 decades as a computer hardware consultant and troubleshooter, providing services to various government departments such as customs and income tax. His diverse background also includes teaching children with special needs, showcasing his dedication to making positive impact in different spheres. An avid writer, Mr. Jain penned an article on the Charity Birds Hospital in Delhi, which was published in the Young Giants of America publication in 1998. His passion for exploration has led him to travel extensively across India, including Lakshadweep, Andaman and Nicobar Islands, as well as Dubai. Beyond his professional achievements, Mr. Jain is a lifelong learner with a keen interest in studying electronic circuits, legal history, and jurisprudence. He also enjoys visiting archaeological and historical forts of India, reflecting his deep appreciation for the nation's rich heritage. Please join me extending a warm welcome to Mr. Sanjeev Kumar Jain as he shares his profound insights and expertise with us today.
Yes, thank you, Mr. Bhattacharya, for introduction on myself, and I thanks the Durgapur Government College, the staff, and the entire faculty members and the students for inviting me to this particular session on IPR, the insights of the IPR, and Mr. Bhattacharya, I seek your permission to share my screen.
Definitely, sir. Please carry
Yeah.
on.
Yeah, so I just begin with a small presentation on what exactly is IPR and what are the benefits arising out of the IPR in our day-to-day society. Is my screen and visible to you, everyone, and the audio clear?
Sir, audio is clear, but screen is still not visible.
Okay. Is the screen visible now?
Yes, sir, the screen is visible. Okay, sir, it's fine now.
Yeah. See, now in order to give you the overview of intellectual property rights, I begin with In day-to-day environment, you will see corporation across the world are spending huge chunks of money, not only corporation, individuals are spending huge chunks of money on innovation, the universities and educational institutes in research and development. Like in Delhi, we are having AIMS, then we are having Indian Council of Medical Research. These are growing at a drastic rate. With the development of technology, there will be more areas of potential conflict between the human rights and IPR in the future. The right of social and cultural rights and should be embodied within the domain of IPR. When I say within the domain of IPR, we are having conflicting views because what happens, law says something and sometimes there is a clash of the law and the cultural rights. And this is where the IPR comes into the picture. Now, in order to strike a balance between the commercial interests embodied in human rights with the political scope, the political history, we have to strike a balance between concerns. So, what the balance has to be both the sides. It should not be that a corporation is exploiting a particular farmer or a farmer is taking advantage of the corporation products, both the ways. So these, whatever the provisions are being there put in IPR, their aim is to safeguard the common good from the potential exploitation by IPR holders. However, a generic resistance in international level is apparent on the issue of widening the scope of human rights. This is a debatable issue. So now here I begin with what exactly is IPR. Now, intellectual property right is something which is produced by human intellect and creativity, which has got some commercial value. Very often tangible in nature, but usually contained on a tangible, fixed medium such as paper, CD, computer chips, integrated circuits, or even scriptures on the rock. They attract certain goodwill. Is there some issue?
Excuse me, sir.
Yes, you are very much audible.
Sir, I think, sir, can you switch up your
Should I
video?
stop?
No, sir. You can switch up your video so that net can be stable. Okay.
Is my voice and screen visible?
Your screen is okay, sir, but your voice is breaking because of network issue. So I suggest please switch up your video. Only the presentation should be there. Then it will be okay, sir.
Yeah, yeah. So in order to save the bandwidth, okay, okay, okay.
Okay.
Yeah, no, yeah, yeah. I hope now it's becoming clear. Is the audio clear now?
Yes, sir. The audio is clear.
Yeah. Okay. Have I missed anything in the introduction?
Hello. No, sir. You have not
Please
missed
suggest.
anything.
Have I missed
No, sir. You just carry on with
anything in the
whatever
introduction,
you
or
like.
should I repeat again at your end?
No, no, sir. You carry on. You carry on.
Yeah, yeah. Okay. Yeah, are my slides visible now?
Yes, sir, visible.
Please respond. Are the slides
Yes, sir, visible, sir.
visible now? Yeah. Okay. Now, what exactly is intellectual property? Human intellect and creativity, which has got certain commercial value. Yeah. Okay. Now, very often intangible in nature. I hope everyone knows about hardware and software. All the hardware that is in the IT sector, we can have that touch feeling. But when I say about the software cannot be touched as such. You have to feel it. It's just like how, for instance, you are having a music system, the music instrument, the music hardware. You can feel and touch. You are present in that supplying the voltage to it. You are extracting the output into the speakers. But when it comes to the music, means the singer's voice, it can only be felt. It cannot be touched. So same way, the whatever I'm saying, the intent, because it is intangible in nature, it attracts certain goodwill. And this goodwill very often, I mean, when I do advocacy, people come up with industry right vested in the asset, not the asset itself. Now, in our day-to-day environment, you'll be seeing when attesting certain documents. That intellectual property, notaries rules 19, certain examples which I put up in my slide. An idea is an IPR. An idea could also be in a right method, secret or designed, but exactly some the brand trade name is an IP, an IPR. Relations I have written about the this 2019 major amendment. Semiconductor, we are having law tort as a which have been succeeded by law of tort also. Now, coming to the copyright, as I have talked in the legislation, now copyright includes some originally literary, dramatic, musical, and artistic works. It could be computer software, it could be engineering drawings, it could even be some, say, chemical drawings or on certain biodiversity product. Then it could be a cinematograph films, it could be sound recordings. Now, copyright is right to reproduce, make, copy, adaptations, and translations as applicable. Okay, and its term is usually lifetime of the author until 60 years following the death of the author. Now, we are having broadcast reproduction rights, which generally these media people, the print media or the electronic media takes. This is for 25 years. The performer rights are protected for 50 years. One important thing that I would like to say, the author's rights, the moral rights, the authorship, or its object are subject to alterations. Like somebody makes a copyright, later on he or she is free to make a alteration to the original subject. The originality is very, very important. In any kind of a dispute that comes up, the very first thing that we see is the originality. Then we are having a resale share right in the original copies. Like for instance, Hindi movies, what they do, they appoint certain producers or certain other companies across the different countries. They have tie up with them, and then what they do, they share the right in the original of the original copy along with whatever the fees they are charging. Now, some examples of the copyright works which I have compiled. It includes literary work, which includes novels, diaries, poems, ghazals. The musical works are the symphonies, jazz, pop, orchestra. The choreographic works include dance and ballet. The artistic works includes paintings, engravings, sculptures. On artistic work, I was having a case. This was related to an order of merit of Maharaja Ranjit Singh, which is held by uh, this Victoria and Albert Museum in London. So we were having a dispute on the subject of photograph. What this particular museum, they took over this particular order of merit of 1839, and how they acquired it was acquired by them through an auction in London. So what they did, they after acquiring this particular order of merit is nothing but a sort of a medal. Okay, and this particular medal was with the Victoria and Albert Museum. So we approached them. How come you have applied copyright on a subject which belonged to basically Indian subcontinent? Because in 1839, Maharaja Ranjit Singh capital was Lahore, and Lahore is in Pakistan. So we had a great trouble in jurisdiction issues, because now Pakistan is no more in India, but the majority of the population, the migrants, they shifted to India. Now, how come this particular order of merit, which was basically in Punjabi or Urdu form, could have a, copyright issue in London? That too in year 2020. We had a dispute in 2020. So somehow we approached them. We looked at certain laws in India. I mean, you can take the photograph of any sculpture. There's no photo this issue because our law does not have it. But in UK law, it was a different issue. Acquiring a photograph was a lawful activity. So we had to. Still, the matter is go there, and now the sort between the two nations, it has to be sorted out under a umbrella scheme, which is held by this WIPO, that is World Intellectual Property Organization. Anyway, these cases continue it to their destination. Now, further going, it includes architectural works, the buildings, then figurative works, maps, drawings, and charts of the scientific nature, cinematograph works, movies and videos, photography works, photographs, and photographs. Photographs are nothing but impression of the ink on the metal. Then we are having program works, which we call it as software programs or the computer programs. They all are protected by copyright. So you will be seeing there are a lot of open source softwares, and some of the softwares they are not open source. For example, by Microsoft, which you have to purchase from the market, whereas open source are free to download. Now comes the next chapter of geographical indications. The geographical indication of goods. It is an indication used to identify agriculture, natural, manufactured goods originating from a definite territory in India. Here I am talking particularly about India. Please note that this act holds good only in India, not abroad. Now, it should have a special quality or characteristic of reputation based upon the climatic or production characteristic unique to the geographical location. So, when I'm saying about India, and some say foreign person in a foreign country, they try to infringe upon the copyright or the GI tag, how it is to be dealt. It's a very tricky method. What for this, the applications have to put in local courts. We have to take examples of the geographical indication: sawadis, Alfonso mango, Nagpur orange, Kolhapuri chappal, Bikaneri bhujia, and like Madhubani paintings, or we are having lots of mural paintings also. Now, any example of the law can apply representing and protecting the interest of the producers. The registration of a geographical indication is for a period of 10 years, and its renewal is permissible for further periods of 10 years each. Now, since I've talked about Darjeeling tea, so I thought I would better talk more about Darjeeling tea. It's the most coveted tea in the world. You will be surprised to know, for example, we are having only 50,000 kilograms of production, supposing. And in an international market, it was Darjeeling tea got passed off in the strength of say 1,000 kilograms. So how does this 50,000 extra came up? Because the total production was say only 50,000. And how come the 50,000 further end up in the international market? So what was happening? Other tea manufacturers from other countries like Sri Lanka or elsewhere, they were selling their tea as Darjeeling tea, which is an unfair trade practice. And there have been many disputes regarding this. What exactly was happening? This Darjeeling tea, this Darjeeling world is also protected, and Darjeeling tea is also protected. I will tell you how. The Darjeeling Association was founded in 1892, and they achieved international status similar to champagne or Scotch whiskey. Now, this Darjeeling logo that you see beneath this on this slide, this logo as well as the word are established in 1999. Now, there was a very interesting case in Calcutta. This was related to ITC group of hotels. Some ITC Sonar is there in Kolkata, and they are having a lounge called Darjeeling Lounge. So the dispute arose. How come you are using our word? But here the issue was that they were using this Darjeeling Lounge since the beginning of their hotel, and this GI tag was achieved at a later stage. So in that particular case, they won the case. Means Darjeeling Lounge was held as valid, but any instances of using the word Darjeeling or Darjeeling tea, once we had attained the GI tag for Darjeeling, it cannot be used. That can be very well challenged in the law. Now, in West Bengal, when I was going through government of India, I found there were around 28 products of GI tag. I would mention the Darjeeling tea. Like why I have used the word one and two Darjeeling tea, because one is for the word and two is for the logo. So Darjeeling tea is that respectful. Secondly, we all know the controversy of I suppose. Bengal got it, and in 2019, Odisha has also got it. So nobody lost the battle. So because what has happened is Bengal is having this Rasgulla, whereas Odisha is having a different or a distinct process. For Tangle, what is here happening? This is the traditional as per because Section 2F of a GI Act is defining the nature, an indication which identifies the good as agriculture, natural or manufactured. By manufactured means it could be a handicraft also, or it could be an agriculture. Like I've used these words, Darjeeling tea, then Gobind Bhog rice, covered under the heading called Act. Now I come to the trademarks, the uniqueness related to the trademark. A trademark is a sign which can distinguish the goods of one trader from those of another. Sign includes words, logos, pictures, or combination of these. A trademark is used as a marketing tool so that a customer can recognize the product of a particular trader or a particular brand. To register the trademark must be distinctive, not deceptive, or contrary to the law or morality, and not identical or similar to any earlier marks for the same or similar goods. Now, here, since I've used the have any patent, but it is still a closely guarded trade secret. Came up in the market was invented in 1886, and its formula is a trademark while copyright protects the packaging art. The shape of the Coca-Cola bottle is protected by both and a very unique design design of the bottle. No other soft bottle. Choosing the lot of use design should be ready for the potential conflicts also.
Hello, 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 sir. Are you there? Hello, hello, sir. Sir, you please rejoin. It will solve the issue. Please rejoin, sir.
Yes, is the audio clear?
It's clear now, sir.
Yeah.
You can talk like that. There is
Yes.
no problem.
Okay. Yeah, I was on this particular thing, choosing the correct trademark. Is the slide visible?
Yes, sir, visible.
Yeah. So any points which has been missed out?
Sir, we got it from the slides. We could not hear you, but it was written in the slide, so we have
No,
it.
no, I was giving a case example of Sony Apparels versus Sony International.
No, sir, we did not get it. You
You
can
did
repeat
not
that.
hear this.
No, sir, no, sir.
Okay, I'll just tell it in brief. There was a case related to Sony Apparels versus Sony International. That Sony International company, as we all know, is the international giant who is making the consumer electronics, who's making computer hardware, and they enjoy a very good will across the whole globe. And there was a small time manufacturer in West Bengal who was a clone, this garment manufacturer. So what he did, he used the trademark of Sony as Sony Apparels. Now it was a very funny situations because Sony never manufactured garments. So this case went to the court, and obviously, in the very first blow, the matter was given in favor of Sony International because they enjoyed a very good goodwill. So that was the infringement of the trademark, and there the international implication was very tough because that garment manufacturer had to stop the business and even pay compensation. Now, coming to the 10th point, because one has to seek a professional assistance also for trademark, because at times, supposing we are in India and somebody is trying to say launch a product similar to Coca-Cola, then they have to study the trademark implications also, because one should not be, it should not be like passing off. It should not be deceptive. It should be distinctive. So, the choosing of the correct mark, that is the trademark, is very, very essential. And all the points what I am discussing, they hold very much relevant. Now, coming to the patents, a patent is a legal title granting its holder the exclusive right to make use of an invention for a limited area and time by stopping others from, among other things, making, using, or selling it without authorization. So far, I mean, from my experience, I'm not saying from others' experience, this patent subject is very, very complicated and tiresome, because one has to really do a lot of hard work. Even in the disputes also, we have to do a lot of hard work, because copyright, GI tags, these are much simpler methods in having in sorting out the disputes in IPR. So what happens in the terms of patent, when the patent is authorized, the applicant must disclose how this invention works in sufficient detail. Whatever the patented product is there, one has to tell in each and every detail how it is going to work out. When a patent is granted, the applicant becomes the owner of the patent, absolute owner of the patent. Like any other form of property, a patent can be bought, it can be sold, it can be licensed, or even mortgaged. For example, an author or a patent was granted to a particular person, but his health was not up to the mark. So he can sell it off within his lifetime. Now, patents are territorial rights. So, an Indian patent will only give the owner rights within India and rights to stop others from importing products into India. Here, what I mean, supposing a fridge manufacturer is there in the Germany and a fridge manufacturer is in India. So, whatever the things that are being used by the manufacturer in India, they will be applicable in the Indian subcontinent only or the territory of India, not in other country. Now, as on debate, India is fully in compliance with its international obligations under the TRIPS agreement. Once again, I would like to ensure, am I audible clearly? Am I audible?
Yes, sir, you are completely audible.
Yeah, now the Patents Act 1970 has undergone three major amendments: 1999, 2002, and 2005. By 2002 amendment, the term of all patents was uniformly made for 20 years. And the third amendment in 2005 had major implications on product patent protection for food, pharmaceutical, and chemical inventions. Now, coming to the protection of patent, it is the basic idea of granting. What is the basic idea of granting a patent? The applicant who has applied to the government for the right of the patent and in return for the monopoly given, one must disclose everything about the invention in patent document. Means the description should be from starting to beginning. It should not be that it's a partial description. The duration is generally for 20 years. Then patent is generally done for an invention. Here I want to make it very, I want to clarify there is a difference between innovation and invention. Patent can be applied for a product or a process. Patentable invention must be new. It should involve an inventive step and industrially applicable. Then comes the priority date first to file. For example, here a company is making a particular drug in the field of, say, oncology, that is cancer. Another company is also making a same drug, same kind of salt. Date is chosen. Whosoever first come, first served. Now, IPR is a tool to compete with multinational. Now, I'm giving a case of a Gold Touch Technologies. This particular company, Gold Touch, used to make peripherals, IT peripherals, that is keyboard, mouse. It was a very small company in comparison to Microsoft, the giant. So they developed an ergonomic keyboard maneuvered into different position to suit the user needs and mouse design. And they had a mouse also along with this particular keyboard that you will see in the next slide. They filed application for patent and they approached the Microsoft for licensing. But what happened when they were approaching a year later, when they had developed this particular mouse, they found that the novel mouse design, which was patented by them, was found incorporated into the Microsoft mouse. Means Microsoft had copied the Gold Touch mouse as a Microsoft mouse. So what was happening? The Gold Touch started losing the sales, and the product which was branded with logo Microsoft is more acceptable than lesser known Gold Touch. People did not know who Gold Touch is, whereas they were the original creators of that particular design. Now, power of Microsoft logo greatly reduced the potential sale of Gold Touch despite Gold Touch design, that is the originality. Only because of their patent, Gold Touch could even think of stopping multinational giant like Microsoft from selling the patented product. So, now coming to the next part, which is not there, the law of tort. Tort is, what is tort? Tort is any civil wrong. So that confidential information, it could be confidential information, could be under a contract, employer employee relationship, doctor or patient relationship. Okay, and its protection is generally done in the law of tort. Now, if supposing an infringement occurs of the confidential, recipient needs to show that information is confidential Recipient who obtained this information uses it without the consent. Means they have not taken the consent of the original person. Now, here original person, supposing it could be a doctor, it could be a patient. But if it is lying with a third person, then of course the consent has to be there, and then they have to look in the damages suffered by the owner. For example, if it's a very confidential information about, say, somebody's health, and it gets leaked out, it damages the reputation. Then protection for industrial designs. Protection for industrial design that are new or original. It is only given not for an enhancement. Supposing A has made a product, and B, what B does, B also makes the same product but added some design on it. But that doesn't remains as an original product. So designs are feature of shape, configuration, pattern, or ornament. So often a dispute when it comes up, we even have to look at the shape, weight, and volume. The design must be applied to an article, and the design must be applied by an industrial process. And of course, it should be appealing to the eye also. Now, when it comes to commercial strategies, commercialization of IPR is to encourage people to bring new ideas and creation into the market and make it marketable and profitable. Okay, please look at the words marketable and profitable. These are the commercial strategies, and the product should be carrying some novelty. And generally, what happens when a new product is launched? The manufacturers often, without registering it, what happens in many cases, what I have seen, they start marketing the product and then later on they go for registering. So they incur huge losses. Now, protection under the law of tort. Not tort, law of tort is nothing. There is no, it is based on a common law or common sense, you may say. There is no legislation passed by parliament in this matter, in law of torts. Okay. And it is enforced by court decision. That is the realistic school of jurisprudence. And the precedent is generally the strict application. By precedent, I mean the courts have taken such view of it in the past for a similar case. Now, there's a very interesting case of Honda Motors versus Charanjit Singh. In this case, what had happened, this plaintiff, they were using the trademark Honda. Honda Motors, as we all know, is the brand name, a respectable brand name in automobiles and power equipments. And this particular defendant, that is Charanjit Singh, he was using it for manufacturing of the pressure cookers, which are used in kitchen or restaurants. So he had started using the mark Honda. So he brought the applicant, the plaintiff brought an action of the suit against the defendant for passing off the business of the plaintiff. Now, in this, the judgment was held that defendants' use to mark Honda could not be said as honest adoption. In the past also, I gave you the example of Sony Apparels versus Sony International. Same thing over here also. Because the protection was there in Sony Apparels versus Sony International, the protection was under the law of trademark. Here it is under the law of tort, because they were passing it off. Now, importance of IPR. It differentiates your products and services from others. It fosters an environment in which creativity, innovation, and invention can flourish. Please look at three words which are very important: creativity, innovation, and invention. The coexistence has to be seen. Then it keeps away the competitors and pirators. By pirators, I mean the pirators could be from any field. Okay, please do not think in terms of pirators that it is the pirater of Caribbeans, because that is also there was a dispute on that particular movie also. Then it promotes your products and services and creates a loyal clientele. Infringement checks by IPR societies. Now comes when I saw your syllabus, I saw that there's a lot of being focused on the biological diversity. The relationship between objectives of convention of biological diversity and intellectual property rights is a subject of continuing debate. Equally controversial is the effect of agreement on trade-related achievement of CBD's objective and sustainable development. Now I will talk on what is CBD. CBD is a convention on biological diversity which originated in 1993. Its objective was to stop unfair exploitation of biowealth and traditional knowledge of developing countries by the signatories. By this, I mean to say, for example, somebody is making a handicraft in the remote, say, township of Murshidabad in West Bengal, and using AI or other techniques, they can infringe very well on the traditional knowledge of that particular person. So, who will be incurring the loss? Obviously, the traditional knowledge held by the person in Murshidabad. So, aims of the CBD are the sovereign rights of the members on their genetic resources. Then, prior consent from country of origin to facilitate foreign access, equitable sharing of advantages and transfer of technology at intervals with the members. Then IPR regime. By IPR regime means all the TTs, all the policy makers, they should not negate the CBD's objective. Often we are having a clash of two laws. By two laws, I mean to say that CBD might be saying something, say they are trying to protect biodiversity park, say of Pachmadi. But at the same time, IPR regime, say some steel manufacturer comes up and he tries to launch a factory in that particular biodiversity park. So this kind of a clash is usually there. So one has to see that the CBD's objective are not lost. And it is to shield the right of the supplier of genetic resource. Is that the rights of the farmers? There exists a one more thing. There exists a gray area where CBD offers minimum guidance in context of character and mixture of advantages. What constitutes a good and equitable share, and who all are the beneficiary is not clear. Convention is there, but some clarity is also missing. Now, I'm talking here in this particular slide. I'm talking of the journey ahead in biodiversity and IPR. At national level, I'm not talking of international matters. I'm not talking of because of the time constraints. Only at the national level, developing at national level, policymakers have to look into several aspects. They have to develop and implement access and benefit sharing regimes with minimum binding standards in national legislation. Whatever the law they are making, they have to take care of it. Then they have to define core intellectual property concepts carefully in national legislation. Then you have to utilize the exclusion to life patenting under Article 21 of Constitution of India. Article 21 deals with life and liberty of the individual, which is granted by the Constitution to each and every individual of the people of India. Then they have to ensure sui generis system that are consistent with CBD obligations. Here, sui generis is a Latin expression that translates of its own kind. Of its own kind is reflecting on the uniqueness of the product. Then they have to record experience of trips, that trade related aspects of intellectual property rights and CBD disagreements. Okay, there are a lot of disagreements and encroaching on another's domain. Then provide a forum to allow indigenous people to develop strategies on the preservation and protection of traditional knowledge. Then the consideration on development of registries of traditional knowledge. Just as we are having registries of IPR, we need to have the registries of the traditional knowledge also. Ensure that national intellectual property offices are adequately resourced and assist in articulation of human right principle as they relate to intellectual property rights. Now, necessity of biodiversity conservation. As per Gurudev Rabindranath Tagore, nature is not just a storehouse of force, but also a dwelling of man's spirit. Nature is living entity and divine. Now, here Gurudev Rabindranath Tagore expressed his disgust against the greediness and against all swelling urbanization and wrote, as Sabyatar Prati in Bengali, I think you may be calling it as Shobyatar Prati from Chetali in 1896. I mean, it's a Bengali word which was translated as give back that wilderness, take away the city. The weariness of the modern urban life is so benumbing that Tagore directly wants back the green era of the innocence for being liberated from all consuming greedy modern civilization. In his ecological and eco-aesthetic thinking is prominent in some of the Tagore's dramatic dance dramas such as Mukdhara or Waterfall. And with this, I thank everyone. There is a language of harmony and religion of forest and environment in the nature which human minds are yet to realize. There is no end to it, and it's a continuing debate. We are always searching for new things, new destinations, new horizons, and often the questions of ultravirus and intravirus, which are there in the lawful field, they keep on happening. And with this, wind up my this presentation, a very basic on IPR. And if there are any questions, please raise it. And the all the participants, they are free to send me an email also. My email, which is there in the very first slide.
Thank you, sir.
Yeah,
Thank you so much for this enlightening talk. I hope we can have your presentations. And now the floor is open for questions. Participants can unmute their microphones and ask their questions directly.
yeah,
Please carry on.
yeah, yeah. Okay, okay. Hmm. Say they are repositories and certain IPR societies. You can become a member of those particular society. IPR societies. There are IPR societies in the musical world, and there are IPR societies in the logo, in the trademark also. Okay, they generally keep a directory of the trademarks which are being registered. Then you can approach the uh, registrar of supposing you are making a for a company. So you can approach the registrar of companies, or you can approach the uh, logo repository, and you can see what kind of logos are being used. Is your logo distinctive or similar? That you have to check it out. You have to search. You have to search. You can see my last slide. We are always searching your new horizons. Yeah, yeah. Not only internet. When you just get in touch with the people who are related to IPR, they will guide you. No, 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 no. The societies generally decide. They don't keep very big fees as such. They are nominal. Yeah, and particularly you can even look at the archives. If you are having certain issues, you can even look at the internet archives also. Yeah. Okay. For example, you have made a logo. You can go to a certain search engine like Yandex and upload your logo and see if any similar thing is there. What happens? It checks the billions of and millions of similar designs in the repository of their database. It may be time consuming, but you will come to know whether your design is unique or not. No, this service is completely free. This service is completely free. Yeah, efficient. See, one more thing. If it's your 100% unique logo, you should never share it, because we never know about the cyber fraud. Since I come from the cyber field, no, we do not know how, supposing somebody who has hacked the system, or who has infiltrated into the server where that repository is kept, might misuse it, because by the time the results come out, and he may use it elsewhere and do the registration. What generally happens, see, people with the pure mind often looks for their this product They do not go into the intricacies of the registration and other kind of legal processes. In one of the slide, I made it very clear. Effect of marketing before the registration. It's a very grave mistake. Yeah. So no, no, you can do one thing. You can do one thing. You made some make some changes into your logo, and then change. Try to say it. Not exactly. Not 100% replica. Yes. 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 Yeah. See, this is a very long process. I mean, the time is very short as such. Okay, you have to upload the pre-final logo. Once again, I'm giving you a tip, not the 100% replica. Okay, and you keep the final logo with you. So once, if you are able to see that your pre-final logo is deceptive or is has been used or somewhere, then you are not submitting the original one with you, because original one has to be unique. It has to be guarded. It has to be closely guarded. Okay, so this has to be kept in mind, please. Generally, what happens when you have designed a logo and you want that its uniqueness, you have to hide certain aspects of it. Okay, and suppose you made a star on it, so do one thing: remove the star and then upload it. Okay, even if it goes in a somebody copies it, you are not affected by it. Mhm. Yes. Yeah. Yeah. Yes. Yes. Yeah. 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 See, yeah, okay. Your question is again very debatable one, because what is happening? Uh, I mean, I'm giving you a case law of Canada. There are particular advocate. He made a case law from AI. Okay, and there the judge was very much smart. He had, I mean, gone through that particular case law. So the very first question he asked about the case law, that because that particular case law for which he was trying to get the wrongful gain was done through AI. See, AI can never meet the human intelligence, the emotions. Okay, and if any product is which is made with AI, what is the creativity of the human being? I In the very first slide I said about the human intellect. I did not say anything about the computer's intellect. Yeah, see, taking a help is a different thing, but after all, the creation has to be yours. See, taking help is not an issue at all, because no, no, it will not affect as long as it's your creation. Like, you may take the help on the matter of design, you may take the help in matter of, say, font or some kind of a thing. Okay, it could be a 3D. Do you think AI will be able to create 3D? Maybe, maybe. So this maybe is there. And if you are taking the help, somebody else could also be taking the help. So the dispute will definitely come up at some stage or the other. The rules are not clear. Anymore, please? Yeah. Okay. listen to me. First of all, you have to distinct what the patent is a completely different thing. For patent, you have to file applications with the patent, their national route, there's an international route. Okay. For copyright, there is no registration as such. Okay. In copyright, you have to show under the Copyright Act, like this was my original work. And supposing somebody has infringed upon it, you have to prove it by the law of tort in copyright. Of course, you will be making use of the copyright, but again, the infringement of the copyright is a civil wrong. So what you can do, you can club up your matter of the Copyright Act and civil wrong together. For there is no as such particular registration. Registration is with the societies who are the watchdog of the copyright. For example, I can say the words, the songs which are being held by musical singers like Kishore Kumar or Lata Mangeshkar, they are copyright observers. There's no registration as such. Okay, often you will see they are, Indian movie songs. Okay, Indian movie songs, they are being taken from the Pakistani ones, and sometimes they are infringing upon it due to the border disputes. The matter remains open because we don't have any such tough law to deal with such kind of infringement. For patent, you have to go through an entire process. You have to file application. You have to first say that your particular product, whatever you are trying to patent, is invention. Please understand. There you have to define each and every parameter. You have to file with the relevant office. Okay, it's a detailed process. You'll find consultants in that particular field for patent registration. Yeah, yeah. And once you get a patent, listen to me, once you file an application, you will get a unique number, registration number. In simple words, let me tell you, for example, notary is there. I took up the matter of notaries, this stamp, the seal under Section 7 of Notaries Act 1952. Where do they file? They file it with the law department. All the notaries information is stored in a repository with the law department. Or say if it's for a state, it will be state of West Bengal. If it is for government of India, it will be with the government of India in Delhi. The database is always there. Any more, please?
Hello, sir.
Yeah, any more, please?
Sir, I have one question. During
Yes,
your talk, you have mentioned about one organization, World Intellectual Property Right Organization.
yes.
Can you please tell something more about that organization? Where is that? What is their purpose? What they do?
Okay. See, that World Intellectual Property is the worldwide forum of signatory countries. It is not restricted to a particular country. Whatever the law that we are having in national legislation, it is acquired from the WIPO, that is World Intellectual Property Organization. Without this, now you are seeing a lot of things now in the news, tariff wars and other things. Okay. Now, World Intellectual Organization is having headquarters in Geneva, Switzerland.
Okay, sir.
Okay, and the member countries have to sign application forms and they become member. What happens? They have to give certain fees to also it. India
Okay,
is also a member of this WIPO since 1975.
okay,
It is a headquarter, and they are the member countries sit together and decide the policy on intellectual matters.
okay,
Okay,
sir.
and
Okay, sir.
WIPO offers services in patents, trademarks, industrial design, this utility models. Then we are having domain name disputes. This is applicable in the cyber world. Domain name disputes. For example, a site held by Supreme Court of India. Now, what the pirates have done, they have made a phishing site, similar looking sites. Then WIPO offers technical assistance to member countries. Then apart from that, WIPO meetings are there. You'll be seeing a lot of meetings, Paris Convention, Bern Conventions, Madrid Conventions. Then this particular organization, you'll be surprised to know, holds a global brand database. Global brand database. Now, in short, I'll just tell you, whenever you buy a product from India or say abroad, on the packaging you will see a barcode. Generally, a 13-digit barcode is
Yes,
there.
sir. Yes, sir.
Okay, that barcode is describing the origin of the country where the product is manufactured. That is
Okay.
known as Global Trade Index number.
Okay.
For India, it is 890. For other, often, it is known to me because I just keep looking at those that particular global database. It is being held by WIPO only.
Okay, sir.
Okay, then they are having national trademark collection of each and every country. Otherwise, how will the matter sort out? Because if just now I told you there was a case about the Order of Merit, which is being held by Victoria and Albert Museum in London, and that particular Order of Merit was acquired through an auction. How we reached there is a mystery to us, and we had a dispute because they put a copyright on it, on the photograph of the Order of Merit, which was made in 1839 or so, maybe 1825 or so. History is not known to me, but in year 2000 or 1996 they had put a copyright on it, so we objected. Finally, that matter has to be taken up by the government, and it will go to WIPO only, or to sort out under the umbrella organization. Because what the law is, we can here take the photograph of Taj Mahal. There is no issue. Okay, but
Yes.
elsewhere in the British law, they had a provision that photograph is a copyright. So such kind of a disputes are there, and they are being generally settled by World Intellectual Property Organization. Amongst the member company, there are appellate authorities over
Okay, sir.
there.
Okay.
Just like we are having